Welcome back, everybody. The Bronx DA's office says it will no longer prosecute people who are stopped at public housing projects under the city's controversial stop and frisk policy unless the arresting officer ensures that the arrest was warranted. Officers who arrest people under the stop and frisk policy, they'll now have to submit to an interview. New York Times reports that prosecutors quietly adopted the new requirement in July after finding many people arrested for trespassing at housing projects were in fact innocent, that they actually lived there. The stop and frisk policy has been criticized for disproportionately targeting blacks and Hispanics. Dominic, I'll start with you. People say this isn't just the distinction without difference. This is significant because somebody has laid down, no, this is what the policy is, and the other boroughs may follow.
Well, I don't know if the other boroughs will follow, but it's very interesting that the state only has one African-American district attorney, and that is in the Bronx, Robert Johnson. And Robert Johnson is the one that's instituting this policy. Bravo to Mr. Johnson. I know some of us may differ at the table, but a district attorney has a legal obligation to uphold the law. And if a district attorney knows that these arrests are bogus, shouldn't the district attorney act on it?
You're a criminal defense attorney. What do you make?
What does it mean that they have to submit to an interview? What does that mean? Do you know what that means?
The cop has to interview with the local ADA that made the arrest.
Well, that's appropriate, but you know what's not appropriate? Making a blanket policy that they won't prosecute any of them. It's the prosecutor's job to exercise judgment and what constitutes reasonable suspicion under the law. You don't just throw out the baby with the bathwater. The prosecutor is supposed to review each case individually after the arrest is made and determine whether it's prosecutable.
Marc,
the cop investigates and the DA prosecutes or not prosecutes.
That we've debated recently when we talk about what is your reasonable expectation of privacy? What is your reasonable should you accept, if you live in the 5 boroughs, that depending on the color of your skin or your geography, that you should have to submit to more intrusiveness than somebody else? And should you be considered a suspect because of your appearance here on fill-in-the-blank street, rather than if you lived on Park Avenue? You represent people, I'm sure, who have had to live through this.
Here's what it is. The U.S. Supreme Court has a purely objective test for determining whether reasonable suspicion or probable cause exists. So even if the officer has race-based pretextual motives, if he can articulate a legitimate violation of the law...
Time out, though, and I'll let you finish.
Go ahead.
Here's what we know from the reports. Furtive movements.
Yes,
what is furtive movements? Nobody can even define that right now. So how is that legitimate if we know prima facie that it's just such an open-ended policy, it can be made to whatever the officer wants?
He can make the arrest and the stop and frisk, and then it's the prosecutor's job to determine whether that's going to stand up under the rigors of cross-examination and whether that's a case that should be taken to a grand jury and whether it should be brought. That's the exercise of legal judgment. The cop does his job, and the lawyer decides whether it's a good arrest or whether it's a bad arrest.
Isn't this already 2 steps too far down the road, though? I mean, because the problem with the stop and frisks, it's not just the prosecutions, it's the stopping and the frisking for people who aren't warranted. So that if the DA is doing this to try to curtail the number of prosecutions, maybe he's trying to also curtail the number of stops and frisks because he sees an unfair...
You have redress under the Civil Rights Act. You have a civil suit for a wrongful arrest.
But I agree with Andrew. And I agree that we shouldn't throw the baby out. Isn't there something in between, though? Procedurally, the police should do differently. For example, get a witness to sign off. Oh yes, I am actually here as a guest. And isn't there other interests that need to be balanced here? If you have somebody...
It could be quotas. If they got rid of the quotas, wouldn't that stop this? Because cops don't need this in their life.
That should go out, but that's a citywide policy. And that quota has obviously nothing to do with... Listen, reasonable suspicion to conduct a Terry stop, which is what a stop and frisk is probably the lowest standard there is in the law. And theoretically, police have to make spur-of-the-moment judgments and decide in the instant whether there's reasonable suspicion or not. Reasonable suspicion isn't probable cause to arrest, and it's not proof beyond a reasonable doubt. It's not preponderance of the evidence proof. They have to make a snap judgment. If they blow it, you toss the case. Now, if it's a nonsense pretext, that's another story. But I got some news for you.
How do we know it? We do know certain answers, though, Marc, only on one thing.
Right.
How many of these stop and frisks actually result in arrests? It's so fractional, the
I
numbers.
agree with you, it's
So
garbage.
if we know already that it's not effective, we know already that it's turning populations against the cops that are looking for
Do we know that?
cooperation.
Do we
Yes,
know
we
that?
do.
Because what about the other side of the coin, of the people who are fearful of going into their own housing because there's somebody out there that
We
looks
got
suspicious?
calls when I was on with you to that
We're going
effect
to keep
from
this
residents.
conversation going on the other side of the break. Stay with us.